Ladies and gentlemen, today we will discuss the law of war at sea or maritime law during armed conflict. It administrates how to carry on naval warfare and protection of marine resources, neutral and merchant shipping. This part of law is difficult in assuring those military operations at sea are conducted within the outline of international law, humanitarian considerations, and balancing military necessity. The legal framework of naval warfare is influenced by customary international law, treaties, and practices of the states. So, it has evolved over the centuries. However, there was a Dutch lawyer. He was a jurist as well as humanist. His name was Hugo Grotius. In 17th century, this Dutch lawyer laid down the principles of freedom of seas, and astonishingly, these are the basis of maritime law. And these are very significant development after these principles were laid down by that jurist. And basically, those are very fundamental principles, but those include also Hague Conventions, Geneva Conventions, United Nations Convention on Law of Sea. These three basic documents are considered in that. But the document which was created by Hugo Grotius carried very, very fundamental importance. Now we'll see what is a Hague Convention. Ladies and gentlemen, Hague Convention were conducted from 1899 to 1907, almost 8 to 9 years. These conventions were continuously going on among many nations. They resolved the foundation for law applicable to naval warfare. Because at that time in the sea, every might was right. And the poor nation, the weak nations, they were suffering a lot at the hands of the might. So these Hague Conventions laid down very, very fundamental principles that how we have to carry on naval warfare. There must be certain principle when we go into naval warfare or naval war in the seas. And primarily they emphasized over the distinction between combatants and non-combatants. Non-combatants are the people who are not involved in any combat or warfare, but they have certain sympathies with somebody, some party involved in the wars. And there are some parties or some sailing ships which are sailing in the seas which are totally neutral. They are neither party A nor party B, they are neutral. And this distinction was to be made between those combatants who are fighting and those non-combatants, and especially those who are neutral. Therefore, the Hague Conventions from 1819 to 1907, they laid down certain principles. And there are certain principles laid down for the war on land. Those were laid down by the Geneva Conventions. Whenever the name of Geneva Convention comes, we have to automatically understand that Geneva Conventions will speak on the principles and the laws which are to be laid down for the war at land. So mainly, since these Geneva Conventions, these mainly focus on the land warfare, those conventions, however, do affect the naval operations also. in terms of the treatment of persons at sea. So therefore, whenever we discuss about the Hague Convention or those documents which Dutch lawyer Hugo Grotius created, name of that Dutch lawyer document which he created is San Remo Manual. So that's a great document, but whenever we focus on that, we have to see this Geneva Convention also. Hague Convention and United Nations Convention on Law of Sea, UNCLOS. Now, what are the United Nations Convention on Law of Sea? This specific area of UNCLOS relates only to the legal guidance or legal guidelines it provides for the use of the world, seas and oceans by all people, all nations, by all civilians, by all people carrying business, conducting trade, international trades and all, sailing in the seas, open seas. Since all the nations have to sail in the seas and the oceans, therefore, this UNCLOS also addresses the issues such as territorial waters, exclusive economic zones, and continental shelf.